I think that changing the litigation reform would be the single biggest thing. And you see that in the PREVAIL Act, really common sense reforms to the current state of patent litigation. Patent litigation, for lack of a better term right now, is an absolute mess. And the judicial interpretations have taken us down a rabbit hole where you really no longer have predictability. Whether it's an eligibility issue, an infringement issue, it really affects. The legal standards and judicial exceptions that have been created have just taken us down a rabbit hole where it's practically non-functioning at this point. The Supreme Court, definitely you can see most recently in this term, saying, hey, we tried, and there's no more, we're not going to figure it out. Congress needs to act to change this. And that's kind of the message that many of us in this area took from the most recent denial of petition, even upon the Solicitor General providing and advising the Supreme Court to take up this issue. They don't want to deal with it, so we are really looking to Congress for those solutions. Infringement, we have to change standing requirements before the PTAB. Everywhere else you have to have a standing requirement. I mean, I was a government litigator for years and a regulatory attorney. Not having to have Article 3 standing is like the antithesis of the federal judiciary to me. And so it's very difficult to continue to deal with infringement and other types of challenges when there's no standing requirement. Harmonizing the standard of proof between the Patent Trial and Appeal Board and, again, Article 3 courts would be huge, both on the infringement itself and also on eligibility, because they're being challenged both ways by multiple actors. Those are two of the biggest things that we could do to change the conversations around infringement. Because the system is the way it is right now, a lot of infringers have a very devil-may-care attitude. And they're like, well, we have deeper pockets than them. We'll just drain it all out of them, or completely emotionally crush them to the point where they will just sell us what they have anyway. That's not a way to run a railroad. It needs to not be that kind of a risk calculation. It needs to be taken in a different light. We shouldn't use the American jurisprudence system that way, in my opinion.